Good evening and welcome to the November 2016 Richardson Law Office's Legal Hangout. I'm Steve Richardson, and this evening we're going to continue our discussions of bankruptcy issues and divorce. Last month in October we talked about the issues from the point of view of the debtor. In other words, the spouse that's in the divorce or after the divorce wants to file bankruptcy for various reasons, to get rid of marital debt, that sort of thing. But this month, we're going to talk about issues having to do with a non-debtor spouse, or ex-spouse. What do you do when your spouse or ex-spouse files bankruptcy, whether it's a Chapter 7 or a Chapter 13? How does that affect the divorce? So that's what we're going to talk about. First, a few big bits of housekeeping. Naturally, this is a law firm, lawyer, so few disclaimers, and just so you understand what this hangout is and what it isn't. First of all, we're dealing with New Jersey divorce law. I'm not a family law attorney. I am familiar with a lot of the issues in bankruptcy that have an effect on divorces and family law issues, but I'm not a family law attorney. I'm a bankruptcy attorney. The bankruptcy is certainly federal law. A lot of issues can change from state to state, so we're dealing with bankruptcies in New Jersey, and as well as divorces in New Jersey. So now, naturally, this is a legal hangout on Google Plus and YouTube. It is not a consultation with an attorney. This is for informational purposes, and to hope to get you to be aware of the issues that you need to talk with your attorney. And it's certainly not a substitute for a consultation with an attorney. So that being said, and the bookkeeping out of the way, let's dig right in with what can happen if your spouse or ex-spouse files for bankruptcy. Now, the question becomes, you're in the middle of a divorce and the bankruptcy gets filed. Will it hold up my divorce? Will it delay things? Well, to a great extent, no. If your spouse, you're in the middle of a divorce and your spouse files a Chapter 7 bankruptcy, it takes about 3 to 4 months to administer that bankruptcy. And in the meantime, there are a lot of other issues you can deal with that are not barred by the bankruptcy law automatic stay. You can still deal with child custody, visitation, any establishment of paternity, if that's an issue. Determining what any alimony or child support would be, or a modification if there's already been a finding of alimony or child support, a modification of the amount that is not stayed. Actions for domestic violence are not stayed, and the dissolution of the marriage can go through. The only thing that can't happen is the equitable distribution of marital assets. Because the trustee steps in the shoes of the filing spouse, and there are certain administrative things that have to be done in connection with the bankruptcy before you can really start dealing with equitable distribution. And also the collection of a domestic support obligation from non-assets of the estate. Now, what does that mean? Well, I'll get into that in a minute. But if the spouse that's filing bankruptcy is behind in alimony and/or child support, that can be an issue as far as whether it holds things up, and that can depend on which type of bankruptcy is filed. So let's go on to that question. My ex-spouse is behind on child support or alimony and files bankruptcy. What do I do? What are my options? Well, it depends on whether it's a Chapter 7 or Chapter 13 bankruptcy. Chapter 7 is just as I said, takes 3 to 4 months to administer. It's a straight hit the reset button, get rid of debt type of bankruptcy. Technically, it is a liquidation bankruptcy, so the trustee has to look at the assets to see whether there's anything available to liquidate to pay creditors, which is why equitable distribution of assets can't be done until the bankruptcy is finished, but it takes about 3 to 4 months. Chapter 13 is a repayment plan over time, anywhere from 3 to 5 years. If they're behind and files a Chapter 7, talk to your attorney about garnishing his wages. Wages, what are called post-petition wages, or wages earned after the bankruptcy are filed, are not considered an asset of a Chapter 7 estate. So if they're not paying your alimony or child support, you can garnish their wages even though they filed Chapter 7. So certainly move forward with that. There's also some other nastiness that you can do if you wish. You can seek the withholding, suspension, or restriction of a driver's license, a professional or occupational license, law license, license to practice medicine, any other professional licensure, recreational license. You can really put a crimp in their day for not paying by going through the suspension of a license, and that's not affected by a Chapter 7 bankruptcy filing. Now, there are other things you can do. You need to be careful here and talk to a bankruptcy attorney whether you need to make a motion for the automatic to get the automatic stay lifted in the Chapter 7 in order to proceed with collection efforts. If you want to do something like garnish, offset a tax refund, seize that, or levy on a bank account. A lot of times these assets are fully exempted, and the trustee may file a report of no distribution, but really on the safe side to either get a stay relief order or wait until the case is over. You should talk to a bankruptcy attorney about that. But if it's a Chapter 13, it's a whole other thing. They're behind on alimony or child support. They're obviously filing Chapter 13 bankruptcy to try to get caught up. And as I talked about this in the last Hangout last month, this is a great tool that can be used if you're behind, from the debtor standpoint, from the payor standpoint. If you're behind, you can use Chapter 13 bankruptcy to get caught up. But what if you're on the receiving end of that? What do you do to protect your rights? Well, you're going to want to take a look at the bankruptcy petition and plan, and make sure that they list the proper balance of the alimony or child support. That's the arrearage, the amount that was behind as of the date of filing of the bankruptcy. What's called pre-petition, or prior to the filing of the bankruptcy petition, and determine whether the petition accurately reflects the income and expenses of your ex-spouse or spouse, because you get paid first, which I'll get into in a minute. So if you can force a higher plan payment than what is proposed, maybe by revealing other sources of income to the trustee, if you look and realize that your spouse or ex-spouse is not disclosing all income sources, where you might be able to increase any kind of plan payment towards the arrears. And also you want to talk to a bankruptcy attorney about filing a document called a proof of claim. If you want to get paid, then you have to file a proof of claim so the trustee can pay your claim. This gives you the opportunity to say what the actual amount is. So let's say your spouse or ex-spouse is filed and they list an amount in pre-petition arrears that's much lower than what it actually is. Well, then you have to come in there with a proof of claim and say, no, it isn't that amount, it's this amount. So you have that power and the ability to do that, so you want to make sure that that happens. Now, what happens when the Chapter 13 bankruptcy is filed? and your spouse or ex-spouse falls behind on post-petition alimony or child support payments, post-petition being obviously payments that fall due in the months that follow the filing of the bankruptcy and during the pendency of the plan. If they fall behind on post-petition payments or don't make their plan payments. And if they don't, if the person falls behind in post-petition payments, talk to a bankruptcy attorney about making a motion for relief from the automatic stay. Say, hey, look, you're not making your payments post-petition. I need to go after wages to collect this. And of course, post-petition wages into Chapter 13 are an asset, so you need to move for relief from stay so that you can proceed to collect those post-petition arrears. If the spouse or ex-spouse falls behind on plan payments, which would be the money that you would get to pay the arrears, the pre-petition arrears of the alimony or child support, then you can make a motion to dismiss and say they're not making plan payments. They're not paying, he or she's not paying anybody. So this plan and petition should be dismissed. So you can make a motion to dismiss. But just be aware, yes, they filed in Chapter 13 and they're trying to restructure things and they're trying to get you paid, but never forget that you have a lot of power. Ever since the bankruptcy laws changed in October 2005, there's been a lot of things that spouses, non-debtor spouses, can do to protect their rights. First of all, you get paid first. There may be a lot of other creditors. They may be behind on car payments or some other secured debt, or have other credit card debt, things like that. They may owe taxes that they've got to pay. But you get paid first. Domestic support obligations are paid before anybody else except the bankruptcy trustee on her commissions. So that you get paid up front. So you get basically, after the trustee takes his or her share, you get the rest of that plan payment until you're paid off. And then the payments start going to pay other things. So you get the upfront money. And also be aware that they have to be current post-petition. So in other words, they get to the end of their plan. Let's say it's a 3-year plan. They've made every single plan payment. You're completely caught up on your pre-petition arrears of the domestic support obligation, alimony, child support, but they haven't made post-petition payments. And it's coming to the end, and you don't think it's worth just making a motion for relief from stay or to proceed. They can't get a discharge until they're brought current, until they file proof. They have to file a document called Certification of Supported Discharge that says they paid all their domestic support obligations. And if they haven't, you can prevent them from getting a discharge. They've got to do something. They can't get away with just getting behind again on their obligations under the divorce, support obligations. So that's a way of holding their feet to the fire that they didn't have before. And they must complete the plan and stay current up to confirmation. So in other words, they file bankruptcy, and it can be 2-3 months before their plan's confirmed, but they can't slack off. They have to get right back on the wagon, right back on and make payments again. So if they say they file at the end of this month, the end of November, they've got to make December's payment. They make January's payment. They have to make all their payments leading up to the confirmation of their plan, because they had to file another piece of paper called a pre-confirmation certification that says they paid all these obligations. So there's a check once when you get the plan confirmed, and once when you go to discharge, to make sure that all of your post-petition, all the debtors' post-petition arrears are paid. So you have a lot more power to use to. But what happens if the case gets dismissed either by the trustee or by you for failure to make plan payments? They file the bankruptcy, they make a couple plan payments that fall behind, the case gets dismissed. And then they turn around and file another one. What do? Well, prior to the changes in October 2005, this was a real problem. This was a game that would be played to try and keep the payee spouse at bay. You file a Chapter 13 bankruptcy to keep them from coming after you for the alimony and child support. And then you get behind again, gets dismissed, you file it again, you continue to kick the can down the road. Well, Congress got rid of that nonsense with the changes to the law. And now, let's say you file a Chapter 13 bankruptcy, or your spouse does, and falls behind on payments at some point, and the case gets dismissed. And then within 12 months of that dismissal, they file another Chapter 13 bankruptcy. Well, then you go from what's commonly called the automatic stay to the semi-automatic stay. The automatic stay is only good for 30 days. So you file a bankruptcy again. You have 30 days of the automatic stay, and then it goes away unless you do something. So what the debtor has to do is file a bankruptcy and simultaneously make a motion to reinstate the automatic stay permanently. And to do that, they have to show clear and convincing evidence of changed circumstance. And what that means is, look, I know I couldn't make the payments before. I know my last plan was dismissed for failure to make payments, but things are much better now. I've got a better job. I've got a raise. I'm in a much better position than I was when the case was dismissed, and to make the plan payments. I can do it this time. Honest. All right. You got to convince the judge of that. The motion gets heard. If the judge agrees to extend the stay, then you're back where you were before, and it goes from a semi-automatic stay to an automatic stay, and then continues on. But what happens if, again, in that second filing, they fall behind, the case gets dismissed, and they file again another Chapter 13 bankruptcy? Well, this time, there isn't an automatic stay. It doesn't exist at all. No 30 days, no nothing. And again, a motion has to be made to impose the automatic stay. And again, things are different now, Judge. I can really, really afford it this time, and I can make this work. And in the meantime, there is no automatic stay. They're in bankruptcy, but nothing's stopping you until that stay gets reimposed. So that really makes them scramble around, and gives you some leverage. So that's that. Keep that in mind. Now, my ex-spouse has not complied with obligations under a property settlement agreement and has now filed bankruptcy. Well, now we're not talking about domestic support obligations. We're talking about what they were supposed to do in a property settlement agreement. Pay your debt, your credit card debt. Maybe they're responsible for marital debt, not just their debt, which they're trying to reorganize it in Chapter 13, but they're not paying your debt. What do you do? Well, that again depends upon the type of bankruptcy that's filed. Is it a Chapter 7 or a Chapter 13? Because under a Chapter 7, obligations on a domestic support obligation are not dischargeable. So if once the case is completed, go after them and say, hey, you didn't comply with the property settlement agreement. But if they file a Chapter 13, then they can, to the extent that the plan does not contemplate paying or stepping up to the obligations under the property settlement agreement, then to the extent it isn't, it can be discharged if the plan gets confirmed. So what you want to do is review the petition and plan to see if he or she has the financial ability to comply with the terms of the property settlement agreement. Are they trying to paint a bleaker financial picture than you believe exists? And you can come in and object to confirmation of the plan, saying, hey, wait a minute, my ex-husband or ex-wife makes a lot more than was what is being represented in the bankruptcy, or they say they're paying the mortgage on the marital home. No, I'm paying it. Whatever it is, that they're representing to try and minimize the amount of money, disposable income available for a plan, you might be able to disrupt that and work and leverage a better plan arrangement, plan payment. And so this is important if and makes a difference between complying with the property settlement agreement, maybe under the terms of the plan, and modifying it. So are all income sources being accurately reported? Are all assets listed and valued properly? There's a rule that says that the value of any unexempt assets must be paid into the plan. So, let's say the house has some some real estate or some other asset has some unexempt value. Say it's $5,000. Well, somewhere in there, that extra $5,000 has to be paid. And you can tell the trustee, hey, wait a minute, this asset is worth more than he's saying it is. There's some unexempt assets here, and hold your ex-spouse or spouse's feet to the fire on that particular floor for the plan. So if your bankruptcy attorney and divorce attorney believe that your ex-spouse or ex-spouse is basically trying to pull a fast one, then object to confirmation and bring this to the attention of the court and the bankruptcy trustee. And you may have to go back into family court to rework the property settlement agreement if there was some give and take, or if the scales have to be rebalanced in light of the debtor not being held responsible for complying with some or all the terms of the property settlement agreement. The next question: my spouse filed bankruptcy during the divorce. What do I do? Again, it goes back to whether it holds up the divorce. There are certain things that can continue on. Some things will be held up. But also, if you're still going through, looking at marital assets and resolving a lot of these issues, that bankruptcy petition can have a lot of gold in it. A lot of information. You want to compare the bankruptcy petition to your case information statement. Both are financial disclosure statements that are made by the debtor. In the course of divorce, file a case information statement, file bankruptcy, another financial disclosure. In the case information statement, they may claim an interest in the house. But in the bankruptcy, they say they don't own the house. Well, there have been cases that have said that, if that goes through and the bankruptcy court accepts the representation that you don't own that, then that's what's called judicial estoppel. Another judge has determined and said, yes, we're accepting the fact that you don't own it. So you go in and say, in the family court, and say, my spouse doesn't own the house, it's all mine. So that you want to look for inconsistencies that may be able to help you in that regard. So that can help. You want to consult with a bankruptcy attorney. If it's Chapter 7, for example, you want to consult with a bankruptcy attorney on how that bankruptcy could affect your rights to marital property, such as the home. Let's say that there's been a property settlement agreement has been completed, that you're supposed to get the house. It's currently jointly in joint names, but say your ex-husband or your husband still has to deed the property over to you. Well, what if the trustee is interested in his half of the equity of the property? You might want to sell it. Well, that could interfere with your ability to get the whole house. Ordinarily, if you've got a spouse and a non-debtor spouse, and they own the property jointly, and it gets sold, well, the non-debtor spouse gets her share of the equity, and then the debtor spouse, to the extent it's not exempted, has to use that money to pay creditors. But what if that half is supposed to go to you? So there may be some things that you need to do to protect yourself, especially in Chapter 7, as far as your rights under the divorce. So you definitely want to talk to a bankruptcy attorney should your spouse or ex-spouse file bankruptcy, to make sure that your rights are properly protected and you do what you have to do to protect them. So that's it for this month's episode for Legal Hangout. And the next one is going to be on December 22nd, a few days before Christmas, the Thursday before. Maybe you can take a break from your last-minute shopping and sit down and we're going to talk about New Jersey's drunk driving law. This is the time of year I usually talk about it. Sometimes there's a little bit too much holiday cheer between Christmas or Hanukkah or some of the other December holidays, and of course the New Year, and people get pulled over for drunk driving. So I'm going to talk about that in December 22nd at 5 p.m. So be sure to tune in. And finally, if you liked this episode, found it informative, which I hope you did, please be sure to punch that thumbs up button underneath the video. Give me a like, and that will help spread the word on this video. And even better, if you are enjoying the content of these Hangouts and other videos that I post to this channel, be sure to subscribe to the channel and click the button to subscribe. And then you'll get a notice in your inbox whenever new content is added. So, again, that's it for this month, and I'll see you in December.